The views expressed in this podcast are meant for entertainment and educational purposes only. We do not know what facts are true, do not claim to know the facts, and have not performed our own investigation. Allegations are just that, allegations. We're using the information we find in news articles and other secondhand reporting of these allegations to entertain and hopefully spark discussion. Noah and Bill's opinions of and commentary on these cases are based upon hypotheticals, using their extensive knowledge of the law and personal experience in the courtroom.
Please rise. Court is now in session.
I strenuously object. A legal podcast brought to you by the Pittsburgh law firm of Flaherty, Fardo is now in session.
All those seeking information about the law and legal matters affecting the people of Pittsburgh and the Commonwealth of Pennsylvania, half-baked opinions, and a dose of self-indulgence are invited to attend and participate.
I want the truth! You can't handle the truth!
The defense strenuously objects.
You would!
Call the first witness.
All right, everyone, thanks for being with us here today. Noah, thanks for being here today. It's another day in podcasting paradise, and it's the return of one of our most popular features here on the podcast. That is Case or No Case. Noah, you excited? You ready to roll with this?
Did you just say one of our most popular? I mean, have you looked at any analytics?
I can tell you this. The verbal feedback I've received from the handful of listeners that I've actually talked to, which, may or may not be friends and family, unimportant right now, definitely said, hey, you guys need to bring Case or No Case back.
So, Mike, the podcast producer here, friends and family saying your podcast is good as like your mother saying you're a handsome boy.
You're a nice boy.
But on the other hand, our Instagram does seem to be taking off. One of our posts there, one of our reels has over 13,000 views and counting.
Wow.
So
Wow.
I highly recommend people check out the Instagram, I Strenuously Object podcast.
Great plug, Mike. Great work. What I'd like to do is move through a couple different cases that have made news recently. For those who haven't listened to our first Case or No Case episode, it is basically exactly what it sounds like. We're going to first discuss the facts, the information, the fact patterns and situations that we're seeing. And then at the end of the day, as two attorneys, we are going to render our opinions as to whether the facts we're discussing here give rise to a viable legal case or not. On the agenda today, just to kind of tease what's coming a little bit, we got a couple big verdicts that we're going to get around to discussing at the end. Spoiler alert, those are cases. But before that, we're going to deal with, a little intrigue in the food service industry. But first, what I'd like to do is discuss a case where we have a man in Florida who was incorrectly declared dead by paramedics.
Bring out your dead. Here's one. Ninepence. I'm not dead.
20 minutes later, was found by a sheriff's deputy to still be breathing.
I'm not dead. Yeah. He says he's not dead. Yes, he is. I'm not.
To assess this case, what we're going to do is kind of call from a couple different articles a set of facts that we can consider. And look, these are in articles, they're allegations. We don't necessarily literally know the truth of this. But for the purposes of this exercise, let's just assume the things that the articles have told me and that I'm now telling you are true, okay?
All right.
These are allegations, right? No defamation suits here. We don't know what's true or false. What we do know is the story that we're hearing and the allegations that we have is you have a 65-year-old gentleman in Florida who goes into some measure of cardiac arrest. His daughter's there. His daughter starts administering CPR. That goes on for a while. It's kind of a scary scene, right? He's cold to the touch. His lips are turning blue. They obviously call 911 and the paramedics arrive. When the paramedics arrive, they kind of take over the proceedings, or one would think they should take over the proceedings. They come in and immediately tell the daughter, I'm sorry, he's gone. I think one of the things I read said they did spend 10 seconds kind of feeling for a pulse. The daughter tells them he was breathing. And their response is, no, ma'am, I'm sorry. That was just gases leaving his body. So the professionals come in and declare this guy dead. They leave, right? They're not administering life-saving care because as far as they're concerned, it's too late for that. The medical examiners show up. There's a sheriff or a sheriff's deputy in place to investigate what happened here, kind of whatever the local procedures in Florida are after someone passes away. And a sheriff's deputy notices that this gentleman, who's now under a sheet, because he's been declared dead. They catch him breathing.
I don't want to go on the car. Oh, don't be such a baby.
20 minutes pass between the time he's declared dead by the paramedics and the time that this sheriff's deputy sees him breathing. Now they call a new ambulance. They bring someone, a new set of paramedics in. They start administering care. They take him off to the hospital. He survives.
You think I'll go for a walk? You're not fooling anyone,
So you've got the daughter who's been told that her father's dead. She's literally starting to make calls to the rest of her family, telling them, that her dad passed. Turns out not to be true. He's in the hospital for weeks, but he does recover. Now, I'll circle back a little bit to, there are some allegations that there are some lasting, deficits and physical injuries as a result of what he went through here. But I mean, he walked out of the hospital. Amazingly, they went from making phone calls to say dad's dead to, having family dinner with him. So, Noah, I put it to you. Case or no case?
I put it to you, Greg. Isn't this an indictment of our entire American society?
A couple things first. I mean, who are you asking whether there's a case for? The individual who was declared dead or the daughter?
I'm willing to consider both.
I mean, I'm not sure either have a case under the EMS immunity laws. I mean, I always worked under the assumption, at least in Pennsylvania, and I think the jurisdictions differ. But if they're acting in their professional capabilities as an EMS, I think they're immune in Pennsylvania from liability. I mean, if it's something grossly negligent, the courts may allow it. But what's your thoughts on that?
This is not a particular immunity or feature that I've dealt with. I'm not aware of it. Can you tell me more?
Yeah, I mean, I just remember years ago having a case where they were transporting someone out of a house and they dropped her and she broke her arm, and they were immune from liability because they were trying to help her. So I'm not convinced that you can sue EMS, but I'm looking online as we're talking because I was curious, and it looks like some jurisdictions allow it and some don't. But assuming for this case or no case that we can get past, you're allowed to sue EMS. They're not immune. I think the dad does not have a case. I think the daughter has a good case.
Well, a couple things here. I am not ready to pass a full professional opinion on the question of what the exceptions to whatever immunity there is. And there is some measure of immunity from what I can see in some circumstances for EMS providers. But whether or not that immunity is going to extend to a certain level of medical negligence is an open question. If this case walks in the door here in Pennsylvania, we'd have to do the research to figure out, okay, what are the contours of the obligations here? And where is it that we can find, if any, relief from this kind of immunity? Assuming that you're in a jurisdiction that doesn't have that immunity, or at least that you're in a jurisdiction where there are exceptions to that sort of immunity that you can fall under. It's interesting for you to take the position that you think the daughter has a case and the father doesn't. And some of that, I think, is going to really rest on the extent to which the father suffers actual physical injuries and consequences. So there are two different kind of types of cases that one can talk about bringing here, one of which is a case for the negligent infliction of emotional distress, right? As opposed to looking at the EMS providers in terms of the physical injuries that they cause to someone. Anybody who is in a situation where they're told their father or their spouse or their loved one or their child is dead, and that turns out to be false, they have had to undergo, this immediate, shocking, emotional trauma, start already onto the earliest stages of a grieving process unnecessarily. That is compensable harm, at least within certain confines, right? If there is a duty of care that extends to such a person, and if it's foreseeable. There are cases in the past where they talk about other medical providers and the duty that you would owe to family members not to convey false information about someone being deceased.
How is he, doctor? It looks like he's dead.
Oh my God!
Just to be clear, it looks like he's dead or he is dead? It just looks like he's dead. He's got like blue paint on him or something, but he's going to be fine.
What is wrong with you?
Precisely because your standard here ends up being, is this foreseeably the kind of emotional harm that no one should be forced to bear or should be expected to bear? To me, this lands on that. but finding places to establish duty, to say that the EMS owed a duty not just to the ostensible patient in the room, but to his daughter, is an interesting and open question. So on that point, I'm leaning case, but I don't think it's open and shut.
So Title 35, Section 8151, simple negligence is immune. So in every case, right, there's liability and damages. The liability, they would have to prove that the EMS was grossly negligent or acted willfully to cause this harm. And I guess the question would be whether or not experts say not recognizing a pulse or breath was so grossly negligent. So, I think you could get the liability. But shouldn't she be happy, Bill? I mean, the guy's alive.
I'm sure it's a mixed bag of emotions, right? I'm reminded of the scene in Fight Club where where they take the spoilers for anyone who hasn't seen Fight Club, where they take the clerk at the convenience store out back and threaten his life and find out that he wants to be a veterinarian, that's his dream, not working as a clerk in a convenience store. And then he pulls the gun away and says, okay, I'm going to be back in a year. If you're not on your way to being a veterinarian by then, I will kill you.
Imagine how he feels.
Come on, this isn't funny. That wasn't funny. What the fuck was the point of that?
Tomorrow will be the most beautiful day of Raymond Castle's life. His breakfast will taste better than any meal you and I have ever tasted.
Look, I don't think you get to claim the credit for taking the emotional trauma away once you've given the emotional trauma in the first place.
Yeah, I give her $1 million. The daughter's Maxwell. I give her $1 million. See what Mike says.
I do have a question that may decide whether or not this is a case. Like, how often does something like this happen? I mean, I don't know if it's truth or urban legends, but they say that in times past, this sort of thing where people were thought to be dead and were not happened so often that there was a little bell above the grave with a string going down to the casket, just in case they woke up and found themselves buried alive. They could pull on the string and the bell would ring and we would exhume them. If something happened that often where you needed a little bell to alert everyone, this might be somewhat of a common occurrence. And could they be held liable for something that happens actually fairly often?
I think you've seized on an important issue. You can't just judge these things by the result. If they acted properly and simply missed the signs that this person was still alive, that's not negligence. And in medical malpractice cases or any professional negligence environment, ultimately the case has to be subjected to the review of other medical professionals who can come in and talk about what the medical standard of care is. It's not as simple as you made a misdiagnosis, in this case, a diagnosis of death. You made a misdiagnosis, therefore you're responsible for it. Well, no.
How do you know there was a misdiagnosis? How do you know the gentleman didn't die and a few minutes later came back to life?
I mean, it could, I suppose, be a Lazarus situation. I do note that the fact that the daughter said, no, he's breathing, and was shunted aside gives some indication that this isn't a situation where there was no evidence confronting either a hypothetical court or the EMS in the moment that this gentleman had passed. But I also want to add, I found a quote in one of the newspaper articles attributed to the chief of the Clearwater Fire and Rescue Department, for whom the medics in question worked. And as someone who's, worked in a medical malpractice field for so long, I found this just the most amazing apology, public apology, no less, in the press that I've ever seen on this sort of thing. And this chief, apparently a Scott Ehlers, per the article in question, states, "I apologize for the actions and inactions of our crew during this incident. We have strict policies and procedures in place that were not followed according to our preliminary review. These two did not perform to the standard of care that our citizens expect and deserve." He's like literally admitting the elements of medical negligence. Now, maybe they're free to do that because there's immunity in Florida that they think mere negligence isn't something they're going to be on the hook for anyway. Maybe that's why you've got what in our practice would be an unprecedented level of acceptance of responsibility by someone.
Yeah, I think the case has value. I would pass. I don't want it. As a lawyer, you know what? It's probably a case. Let somebody else take it.
See, no, I strenuously object. I want this case. I think this is a situation where if the facts are as bad as that apology and the surrounding circumstances would lead one to believe, if he was so alive that a, sheriff's deputy is able to see that he's breathing, but your trained, first responders are, are just describing it as gas leaving the body. To me, that's a case. And the only thing I'll add is we separated at the beginning of this the idea of the daughter's case where the duty's a little bit less clear, but the damages are more obvious, from the father's case, the actual patient's case, where the duty that's owed when you're providing treatment and care to someone, that duty is more obvious. But then the question becomes comparing the delay in treatment. How much worse is he because of the 20-minute delay versus whatever medical problem he was already having anyway? If they take him immediately to the hospital and immediately provide medical care, he may still be in the same place he is now. I mean, the fact that he walked out of there seems like something of a miracle. And, it's hard to run out the hypotheticals of, hey, if they treated him more promptly, could he have reasonably expected a better result?
Nah, I don't like it. Go ahead.
All right, let's move on to case number 2 here. Every year I like to go to Buffalo Wild Wings.
Buffalo Wild Wings, you have to be here.
Watch some NCAA tournament games, order a run of wings as they kind of slowly trickle across my my table, and watch 4 games at once on multiple TVs and that sort of thing. So it was an especially appropriate time of year for me to encounter this article talking about a class action lawsuit that's been filed in Illinois against Buffalo Wild Wings. Noah, have you heard this case?
Yeah, I've read a little bit about it.
A gentleman who apparently has something of a history of being a named plaintiff in various consumer-style class action lawsuits has in this case taken it upon himself and found a local attorney to represent him in filing this complaint to sue Buffalo Wild Wings because their boneless wings are not made from wing meat, but rather they're white meat, chicken breast meat, that's breaded and thus more akin to a chicken nugget or that sort of thing than what you would call a quote unquote wing. And I mean, it is certainly true that Buffalo Wild Wings calls their boneless wings exactly that, boneless wings. They do also in other places describe them as being made from all white meat chicken. And I note, in part because I think it's a delightful response, that Buffalo Wild Wings made a public tweet in response to this lawsuit, and the news of the lawsuit, I suppose, which says, "It's true. Our boneless wings are all white meat chicken. Our hamburgers contain no ham, and our buffalo wings are 0% buffalo." So, Noah, case or no case?
Well, I mean, I'm looking at the definition of boneless wings on Wikipedia, and apparently in the industry, boneless chicken wings are not actually wings, but rather are typically formed from breast meat. So apparently the standard industry is to call boneless wings, but use chicken breast meat. It's a dumb case. I guess if you first hear about it and it's a wing and it's not a wing, it's a breast, okay, they're not being factually accurate. That might get you to liability. I don't think so.
My thought is, how is it even detectable to the consumer? Is there a difference in taste? Is there a difference in quality? Is there a difference in nutrition? And if there is a difference in nutrition, I doubt someone sitting at Buffalo Wild Wings really cares that much about that aspect of it.
Yeah, I mean, I am certainly no nutrition expert. A few things, kind of broad strokes here for those with less of a wing eating habit than have I. Among the differences between the boneless wings and traditional actual made from chicken wings, right? The meat's different. You're talking about dark meat in the case of a wing versus chicken breast meat, white meat, in the case of these boneless wings. The breading is different, or breading in and of itself is different, right? A traditional buffalo wing, you're using the skin and you're kind of cooking it on that. You're not breading around it. But this processed chicken breast meat, it doesn't have skin. It's a chunk of muscle as opposed to a distinct chicken part. And so you have to bread it to create the outside that you can then toss in the wing sauce and so on. So, it's breaded. I'm assuming that means higher carbs, but the white meat is generally healthier than dark meat from like a caloric perspective. The cost is interesting too. For most of my life, chicken breast meat would have been more expensive than wings. Now that has changed around, right? Nowadays, based on, among other things, the way in which they kind of genetically treat these chickens, you got, forget where I saw it. I think it was in one of the articles about this case, where, they can pump up the breast muscles of these chickens as much as they want and create these gargantuan chicken breasts, but in the end, the chickens still just have the 2 wings. And so, like, per chicken, your ability to generate these quantities of meats have changed. Other things in the industry have changed. So some of the allegation here could be that Buffalo Wild Wings is pulling a bait and switch that benefits them economically now in a way that it didn't before, because they're providing you with what is cheaper meat.
I can't wait till they genetically modify a chicken to have 8 wings. That's going to look amazing.
It reminds me of the, John Madden's 6 or 8 or whatever it is, legged turkey from the Thanksgiving games for all those years. Yeah. Noah, you asked earlier what the damages are. This is, of course, a totally fair and appropriate question, taking one specific case in isolation, right? You ate a piece of chicken. You weren't poisoned by the chicken. You weren't allergic to something in the chicken that you got. This is why, of course, he brought it as a class action. The whole idea, or one of the main ideas of a class action suit, is to create a civil remedy and relief for situations where the individual harm that each member of the class suffers is so small that the economic incentive to pursue the litigation doesn't exist. And so you take everyone's claims together. Maybe I only got bait and switched out of $7 a chicken. But if that's happened to 1 million people, or 10 million people, or 30 million people, now my case theoretically gets larger.
Yeah, I mean, this is a simple money grab by the lawyers who file it as a class action lawsuit because, these cases against the food and beverage companies, class actions specifically, went from 18 in 2008 to 300 last year. So the lawyers figured out it doesn't matter if it's a good case or not. Is it a case or no case? Legally, I guess lawyers will make money, but it's a no case to me because the only reason we're talking about it is because it's theater of the absurd. It's so unique and dumb that people are writing articles and we're talking about it on a podcast.
Don't we need to see the menu? Was wings in quotation marks? Was there some kind of a disclaimer, an asterisk, and then down at the bottom, was there something on the menu that let consumers know what they were eating?
So I think the phrase all white meat chicken does appear, which requires now the consumer to know the difference between white meat and dark meat to be able to figure out. But that, to me, that's where this case really falls apart and why I think it's no case. I think the average consumer knows that boneless chicken wings are made from breast meat. When they hear the phrase boneless chicken wings, they don't think there's someone in the back pulling the bones out from the various parts of a chicken wing. Like that does not make sense.
Ladies and gentlemen, it has nothing to do with this case. It does not make sense.
Even if you're not measuring this thing by the industry standard definition of the term, look, all the time in kind of the food industry or whatever, we have phrases or turns of phrase, right? That's why Buffalo Wild Wings said in their tweet, I don't need to know that there's not dog meat in a hot dog. There is an expectation that as a human being walking through and living in society, that I know these things well enough that I'm not being deceived by relatively standard phrasing on a menu. And similarly, how many times have any of us been at a restaurant where we're not really sure what some of the words in a particular menu item or dish are? Like, you're kind of rolling the dice on that if you're not sure. I don't think that they're deceiving me. So,
I mean, you could argue from a contract perspective. We had an agreement. This is what you offered me. This is the everyday meaning of this word, and you didn't give it to me. But
the everyday meaning of wings to people is more about the presentation. In other words, the sauce that's on it, the things you dip it into, the celery. You get a plate of pieces of meat prepared in this way. It's wing style.
I think that's fair. That makes sense.
Moving on to, and I think we can kind of couple up a little bit these third and fourth cases, at least as far as our analysis. These are both cases because they've come to verdict. We have the benefit of hindsight now. So just recently, there have been a couple different verdicts that I want to talk about. First of all, there was a hazing case, sad case, freshman in college who passed away. He was pledging a fraternity. They apparently had, I forget what they call the particular this particular trial as part of their pledge process, but they basically quiz you question and answer about, like the fraternity's history. And if you get questions wrong, you're made to drink. It's not the sort of thing that is unheard of around the world of hazing and fraternity hazing and so on. In this case, the poor student in question, his blood alcohol content was like 0.495. He it was an outrageously high BAC. It was an astounding quantity of alcohol to get him there. And you have, a suit was filed against LSU, where he went to school, the fraternity in question, I'm assuming both local chapter and the national, as well as several of the students, the upperclassmen who were involved in the hazing. Anyway, this went to trial, and a jury in Louisiana awarded $6.1 million to the parents, covering both a survival and a wrongful death action arising from this case. I note that apparently by the time it got to trial, there had been settlements with all the other defendants, except for, I think, one of the students, one of the other fraternity members who was being sued, right? The school had already settled out. The fraternity itself had already settled out for various sums. So I don't know what this $6.1 million verdict actually means as far as how they divvy that up. The articles tell me that the family asked for 25 million, got 6.1. That when LSU settled, because it's a public school and these things end up being more public in those regards, their portion of the settlement was just $875,000. So, no, it's a case. The question here is, what are your thoughts about that verdict, the kind of settlement you're seeing there, and just a quick take, because I want to compare it to another case.
It's definitely a case, and the hazing cases over the last 5, 7, even 10 years have gotten a lot of traction, and the numbers have been really big. There was a big case against Penn State. There's an unknown here where the verdict was for $6.1 million, but we don't know what the total recovery by the family was. Right. When I first read that, 6.1 was really low for a good college kid with his entire life ahead of him. The lost earning capacity alone could have been $10 million. Yeah. So, I viewed that probably as a $20 million case, $25 million case, and it's hard to put any number on a life. We'll get into it more with the next case you're going to talk about. You just never know what these juries are going to do. And no matter how many cases you have, how many cases you settle, how many cases you try, juries are a constant unknown, at least our entire careers, don't you think?
Oh, yeah. There is always a wild card factor when it comes around to actually getting to and in front of a jury, right? If the lawyers for the plaintiffs here knew what the verdict at an eventual trial would be, they obviously wouldn't have settled for $875,000, against the university, which is presumably that or the national fraternity are your two deepest pocketed defendants here. You're not going to get that much money out of a college student or the family of a college student who ends up being liable on these things as well.
It seemed low to me. My initial impression, 6.1 million on this type of case seemed low to me.
It is an unsurprising, I think it's an objectively low number. It's a lower number than I would give if I were a juror. It's a lower number than I think is fair when you're talking about actually extinguishing the life of a 19-year-old young man with his whole future in front of him. But, and Noah, I'm going to point out, you are completely prohibited. You used your allotted share of the opening lines from a civil action, which we've played at least twice, if not 3 times in the past year on this podcast, where John Travolta's character assesses what the perfect plaintiff is, and men better than women, and dead plaintiffs versus alive plaintiffs, and so on.
Rich versus poor, and even better than the civil action Travolta opening was a Michael Keaton movie called Worth.
I have neither seen nor heard of this movie.
That really is teaching a law school class. How do you value the loss of life? And I think it's a true story. He was the gentleman who was brought in after 9/11, if I'm correct, to value the loss of the people that were killed. And you had to go and value thousands of lives and put different numbers on them.
The victims and their families will be compensated based on economic value lost. That's where the formula comes in. 80%.
Any fewer come aboard, the lawsuits that result could crater the economy.
Why isn't an equal payment for everybody? My daughter's worth just as much as anybody in a corner office.
But I wanted to compare, back in February, verdict out of Philadelphia where a former Philadelphia Eagle, Chris Maragos, and I may be butchering his name as far as pronunciation, which is an interesting part of this I'll get back to. But he won an award in a medical malpractice case alleging a failure to diagnose and treat a torn meniscus in his knee that he alleges ended his football playing career. And he was awarded $43.5 million. Now, a few things to note here. As I noted, I'm not exactly sure I pronounced his last name correctly. I am a not insubstantial football fan. But, he was a safety and a special teams captain, a special teamer. So I will hopefully be forgiven if my knowledge of the Eagles' prior depth chart doesn't go to the point that he was a household name for me. He was already 31 years old. He tore his PCL and underwent surgery on the PCL to repair it. He alleges that at the time of that surgery, they should have also repaired a torn meniscus that they failed to discover at that time. That subsequent MRIs showed this torn meniscus, but that they put him on an aggressive rehabilitation program that had him running and basically made that tear worse. His knee never healed sufficiently. He got released by the Eagles after the end of that season and has never been able to play football again. Complains he's the only dad among his friend group, can't go out and play flag football with his kids kind of thing because his knee's shot. Let's grant for the moment there were defenses here. The doctor who did this made the defense that at the time I did the procedure, I didn't see any issue with the meniscus. They even suggested that he may have injured the meniscus subsequent to the procedure, right? That he was not disclosing a subsequent injury that he suffered and claiming they were responsible. The jury didn't find that credible, apparently, because they found them negligent. But where I want to focus here is on that kind of eye-popping $43.5 million figure. This isn't a quarterback or someone who was signing like the top-end contracts in the NFL. He had a claim for lost wages. That claim for lost wages was $8.7 million. Still a big chunk. Still a chunk that the defendants here were poking at like, look, you're already 31 years old. You've only made $10 million in your career to date. Is it really reasonable to think that your career was going to last that much longer coming off this PCL injury that wasn't our fault anyway?
Coming off a lifetime of playing football in the NFL and playing football your entire life,
yeah.
And your knees are bad. This was a shock. This was a shocking verdict.
And the question is, why was this such a big verdict? Noah, you know this answer.
Well, a couple things. Dr. James Bradley, this Pittsburgh Steeler doctor who is globally recognized as one of the leading orthopedic surgeons in the world. That's who the defendant was. And highly respected, likable guy, comes across very well. Went on the stand and actually said, if I knew everything I knew now, I still would not have done anything different. That's a pretty defendable case right there when you get a really likable, high-powered, knowledgeable doctor saying that. But what the jury did, Bill, and I guess I can only guess, is they said, yeah, he lost at least $8.7 million on his current contract, but what if he played for 3 or 4 more years? The best part about this case to me was that the jury deliberation was the Monday after the Eagles lost the Super Bowl.
Ding, 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 ding. That's our answer.
What are the chances that, you never know when a trial's how long it's going to take, but this must have started 7 or 10 days, 2 weeks prior to the Super Bowl. And maybe the plaintiff's lawyers were that good that they timed it. But when the jury went to deliberate, it was the Monday morning after the Super Bowl loss. And I think he was loved in the city of Philadelphia. And Philadelphia, for whatever reason, is known as one of the more generous cities in America for giving jury verdicts. It's one of the best places you can ever bring a medical malpractice. So I think the stars aligned, and they awarded 7 times for a missed meniscus what the LSU student family received for the hazing. It just doesn't make sense.
Yeah, a few things to circle around with and maybe kind of clean up. My understanding is he was not on a then existing $8.7 million contract. And in any case, it's the NFL. His contracts weren't guaranteed. He was already released by the team and wasn't going to receive that money by the time that the injury got worse and he was rehabbing, as I understand it. They had an economic expert, come in and project what his expected future earnings were total, cumulatively, and that's the $8.7 million figure. So he was not expected to make that much per year or per contract. That's how much their experts were projecting he was going to make over the remainder of his career as an already 31-year-old football player. But to me, everything here is like the crazy circumstance that this case went to trial, like right before and during the week before, and then to verdict right after the Super Bowl. And then the Eagles happened to make the Super Bowl. And so you've got, jurors in Philadelphia who, are subjected to Super Bowl hype or excited for the Super Bowl. Their team's in the Super Bowl. They love their team. Their team is successful. So there's all these factors going in that make him more likable because the Eagles are more likable, more successful because the Eagles are more successful. Jurors thinking this guy maybe could have been in the Super Bowl this weekend, and instead he's here at this trial, because his career's over, and we think it's these doctors' fault. And that is a wild card, as far as how that goes. Yeah.
When you think about high verdicts, a lot of things have to happen. You really the jury really has to like the plaintiff. It's quite possible that they did not like the defendants or their lawyers, or they angered them somehow. But I also think whenever you get that number, it usually means that a couple of the jurors were even higher. It's usually a compromise in a jury room that somebody was at 100 million, 75 million, and they came down to 43 million, and others were at 10, and maybe they met in the middle. They may have all just started at 40 million. That's possible too. But I feel like, for you to get 12 unanimous, or at least 10 out of 12, that high, wow. It was a shocking verdict.
Yeah, and look, God bless everyone involved. I'm not begrudging the jury or their job there. I think it's interesting, when you compare that award to what a Louisiana jury gave to a person who was killed. It points out just the high degree of variance that's present in the system. The only other thing that may or may not have come to play, certainly after the verdict came out, the plaintiff's attorney kind of cast it as far as these doctors who work for the teams, they should really be putting the patient's interest first, and you should be doing the medical care that's necessary to heal the patient's body and not get the patient back to football as soon as possible. And that there's kind of an inherent conflict in team provided doctors and medical care and facilities, because the interest of the team in getting someone back on the field can be rather different than the interest of the player or his health. Although I note not always, right? Sometimes the player just wants to get back on the field as well, and worry about the long lasting consequences anyway.
Didn't you feel that this case was good for our medical malpractice clients in Pennsylvania?
Absolutely. This is the kind of verdict in almost every case, and the majority of cases settle. They don't go to verdict. But what the defendants and the defendants' insurance companies are always calculating when they're trying to figure out what a reasonable settlement is kind of what the exposure, and in particular, like the likely and then the maximum possible exposure that their clients face is. So it's the risk of a verdict this size that makes all the cases that settle for much less than $43 million settle, because somewhere in the back of their mind, the insurance company, the defendant, what they don't want is, $40 million verdict is placed against me, and the insurance company has to pay all that out because they didn't settle it for, a couple million earlier in the process.
Now here's the other side of the coin. It makes us settling a wrongful death case against a hospital. When I hear $43 million for a bad knee, how do you settle a wrongful death, the loss of a life, for $10 million? To me, it's going to make me reevaluate a lot of what I'm willing to recommend to our clients.
Yeah, I mean, look, in the end, these things are the client's decision, and we consistently will tell them that as we're handling their cases here. All we can do is put the evidence in front of them. And when we're advising, a plaintiff in a case, whether it's a wrongful death case or any case, but especially a case where someone dies, I want to show them both of these articles, both of these stories. I want them to know both things that are in play here, which is, look, sometimes you hit this grand slam and you can get, tens of millions of dollars. And unlike most cases, when you're suing, the hospital and medical practices, that's money you're actually can receive. Now, they'll file appeals and settle for less than dollar for dollar everything that's in there, almost certainly. But, it's going to be a big chunk of change. But it's also possible that, what did we see out of this verdict in Louisiana? You got a $6.1 million verdict that I think is just, against an individual who's not going to have the resources to pay that much anyway. So you've got a giant number in the verdict, but nowhere near that much money actually making it into, the hands of the family who lost this child. Well, young adult, but, they lost a son and a brother and a friend and whatever. And they're seeing nowhere near these same figures. And every plaintiff who's confronted with the decision of how and when and at what dollar value to settle, even a really good, malpractice or personal injury case, they need to decide how much of that risk of wildly different outcomes they're willing to take on. Am I willing to roll the dice to try to get $40 million when there's a chance the jury could come back and say, I like this doctor. I don't think this doctor did anything wrong. Defense verdict. You get nothing.
Yeah. Well, and to me, it led me to believe, at least in this case, that the defendants weren't even willing to pay the $8 million. I mean, do you think the plaintiff's lawyer would have taken $8 million prior to going to trial? To me, I think the offer was less than that. I bet it was a couple million, and they said, let's just roll the dice.
I would think, but I would also be guessing. Yeah. It's kind of hard and dangerous to speculate. These things are supposed to be confidential as far as settlements. It's why the only one we really know out of this LSU case is for the university, because it's a public institution. But you don't know and can't really assume whose fault it was, or if it was anyone's fault when a case gets to trial instead of settling. Maybe the defendant was offering too little. Maybe the plaintiff was asking too much. Maybe both of them are acting reasonably and just have different risk tolerances. It's tempting to try to reconstruct afterwards who made what decision and what was rational based upon the outcomes. But, I am not comfortable making anything other than the barest of speculation about what the actual offers and demands were in this case.
Fair enough.
Well, that will about do it. Thank you, Noah. Thank you, listeners. Hopefully you enjoyed this particular version of Case or No Case. And hopefully you learned something or, otherwise enjoyed the time we've spent together. If so, please subscribe, rate, and review the podcast. Tell your friends, tell your enemies, tell total strangers. If you have questions for our Mailing It In segment or things you'd like us to talk about, feedback for the podcast, email us. That's at iobject@pghfirm.com. You can also see our Instagram, which Mike was kind enough to drop at the beginning, and I will drop again at the end. That Instagram is I Strenuously Object Podcast. And for more information on any legal matters, any free consultations, determine whether or not you've got a case or no case, visit our website. That's we're Flaherty, Fardo, Rogel, and Amick. And our website is pghfirm.com. Until next time, some parting advice.
Jackie, you think we got a case?
Your face is my case.
Noah, are we adjourned?
We are adjourned.